So in the last podcast, I said in the next episode we'd be looking at the extradition hearing of Julian Assange, and there's no podcast this week because it's fifth weekend, but there was so much going on, it was probably too much for a podcast anyway, so I thought I'd go ahead and do a separate video on it. And so I'll go ahead and record it and give it to the patrons, and then I'll probably do it up as a video and put it on YouTube. And I'm not sure if this will be one or two videos because there's a lot to go through. It just depends on how long it takes to talk about everything. But the easiest thing to do is to go through the commentary of Craig Murray, who was at the hearing, and he was actually a British ambassador to Uzbekistan, and he's part of the FCO, and he was the rector of the University of Dundee. So, I mean, this guy knows what he's talking about. This isn't just some random guy with a blogger. And as we go through this, I think you'll see that this is pretty obviously a kangaroo court. So, he starts off, and I'm not going to read out this whole thing. He has given permission to reprint this and spread it around, and so the links to this are in the show notes. I'm not going to read the whole thing out like an audiobook, but there are parts that I'm going to read specifically. But he starts off about how the whole design of the courtroom that Assange is in is about imposing the power of the state and doesn't really have that much to do with justice. And he says, Woolwich Crown Court is nothing but the physical negation of the presumption of innocence, the very incarnation of justice in unyielding steel, concrete, and armored glass. It has precisely the same relationship to the administration of justice as Guantanamo Bay or the Lubyanka. It is, in truth, just the sentencing wing of Belmarsh Prison. Now, we've talked about this in the podcast. Belmarsh is where they've been holding him, and that's where they generally put the worst of the worst, terrorists and serial killers. And please keep in mind, all through this, that what Julian Assange has been accused of doing is going into a chat room with someone and then posting some documents online, okay? He didn't try to fly planes into anything. He didn't try to go into a public place and blow himself up. He wasn't caught under the Houses of Parliament about to light some barrels of dynamite. No, this guy just posted stuff online. He's not a violent guy. And so he says, when inquiring about facilities for the public to attend the hearing, an Assange activist was told by a member of court staff that we should realize that Woolwich is a counterterrorism court. And he says it's true de facto, but there's not supposed to be any such thing as a counterterrorism court in the UK. So he goes on to describe the court, and one thing he describes that I'm not going to get into, but that I definitely want to talk about later on as it becomes important, is the fact that Julian Assange isn't sitting up with his counsel like you would expect, at least in an American court. He's in the back of a court behind a glass screen, basically in a cage. So keep that in mind. We'll come back to it. Okay, so James Lewis was speaking for the prosecution, and Murray relates it. It consisted of two parts, both equally extraordinary. The first and longest part was truly remarkable for containing no legal argument, and for being addressed not to the magistrate, but to the media. It is not just that it was obvious that is where his remarks were aimed. He actually stated on 2 occasions during his opening statement that he was addressing the media. Once repeating a sentence and saying specifically that he was repeating it again because it was important that the media got it. I am frankly astonished that Barrister allowed this. Vanessa Barrister is the magistrate in charge of the hearing. It is completely out of order for a counsel to address remarks not to the court but to the media, and there simply could not be any clearer evidence that this is a political show trial and that Barrister is complicit in that. So one of the things that Lewis wanted the media to know was, it is not true that mainstream outlets like The Guardian and New York Times are also threatened by the charges against Assange, because Assange was not charged with publishing the cables, but only with publishing the names of informants, and with cultivating Manning and assisting him to attempt computer hacking. Only Assange had done these things, not mainstream outlets. Remember that, it's going to be important. And so then the magistrate questioned the prosecution on the veracity of some of these claims. In particular, the claim that newspapers were not in the same position because Assange was charged not with publication, but with aiding and abetting Chelsea Manning in getting the material did not seem consistent with Lewis's reading of the 1989 Official Secrets Act, which said that merely obtaining and publishing any government secret was an offense. Surely, Barrister suggested, that meant that newspapers just publishing the Manning leaks would be guilty of an offense. This appeared to catch Lewis completely off guard. The last thing he had expected was any perspicacity from Barrister, whose job was to just do what he said. Lewis hummed and hawed, put his glasses on and off several times, adjusted his microphone repeatedly, and picked up a succession of pieces of paper from his brief, each of which appeared to surprise him by its contents as he waved them haplessly in the air and said he really should have cited the Shaler case but couldn't find it. It was like watching Columbo with none of the charm and without the killer question at the end of the process. Suddenly, Lewis appeared to come to a decision. Yes, he said much more firmly, the 1989 Official Secrets Act had been introduced by the Thatcher government after the Ponting case specifically to remove the public interest defense and to make unauthorized possession of an official secret a crime of strict liability. No matter how you got it, publishing and even possessing made you guilty. Therefore, under the principle of dual criminality, Assange was liable for extradition whether or not he had aided and abetted Manning. Lewis then went on to add that any journalist and any publication that printed the official secret would therefore also be committing an offense, no matter how they had obtained it, and no matter if it did or did not name informants. Lewis had thus just flat out contradicted his entire opening statement to the media, stating that they need not worry as the Assange charges could never be applied to them. And he did so straight after the adjournment, immediately after his team had handed out copies of the argument he had now just completely contradicted. I cannot think it has often happened in court that a senior lawyer has proven himself so absolutely and so immediately to be an unmitigated and ill-motivated liar. This was undoubtedly the most breathtaking moment in today's court hearing. Yet, remarkably, I cannot find any mention anywhere in the mainstream media that this happened at all. What I can find everywhere is the mainstream media reporting, via cut and paste, Lewis's first part of his statement on why the prosecution of Assange is not a threat to press freedom. But nobody seems to have reported that he totally abandoned his own argument 5 minutes later. Were the journalists too stupid to understand the exchanges? The explanation is very simple. The clarification coming from a question Barrister asked Lewis. There is no printed or electronic record of Lewis's reply. His original statement was provided in cut and paste format to the media. His contradiction of it would require a journalist to listen to what was said in court, understand it, and write it down. So as we've said before, this isn't just a matter of the public needing to know about this. The news media itself is being threatened, and they apparently don't even realize it. When if they would do this thing called real journalism, they might actually be worried. So as far as the magistrate goes, he says, I was left uncertain of Barrister's purpose in this. Plainly, she discomfited Lewis very badly on this point, and appeared rather to enjoy doing so. On the other hand, the point she made is not necessarily helpful to the defense. What she was saying was essentially that Julian could be extradited under dual criminality from the UK point of view just for publishing, whether or not he conspired with Chelsea Manning, and that all the journalists who published could be charged too. But surely this is a point so extreme that it would be bound to be invalid under the Human Rights Act. Was she pushing Lewis to articulate a position so extreme as to be untenable, giving him enough rope to hang himself? Or was she slavering at the prospect of not just extraditing Assange, but mass prosecutions of journalists? And here's an interesting part. The 4 U.S. government lawyers seated immediately behind Lewis had the grace to look very uncomfortable indeed as Lewis baldly declared that any journalist and any newspaper or broadcast media publishing or possessing any government secret was committing a serious offense. Their entire strategy had been to pretend not to say that. And if you remember, we've covered how they've been saying that pretty much in the entire almost decade since this happened. Oh, the New York Times didn't do nothing, but Assange, well, he's not a real journalist. He's a hacker. He's a conspirator, etc., etc., etc. And the next argument, I'm just going to read out the first part, but it's interesting because Lewis said, "The court had no decision to make," he stated. "Assange must be extradited." Yeah, why worry about little things like the law and the facts? Let's just go ahead and extradite him. In fact, why are we even worried about the whole rigmarole? Let's just get a rope, build a gallows, and hang him right now. So Edward Fitzgerald then arose to make the opening statement for the defense. He started by stating that the motive of the prosecution was entirely political and that political offenses were specifically excluded under Article 4.1 of the UK-US Extradition Treaty. Remember that one? That's another one that's going to be important. Now, there was a lot of evidence presented of what we've known all along, which is that the government has been spying on private communications between Assange and his lawyers, something that should be unheard of and even grounds for disbarment. I mean, we're talking about major injustice here. And Murray says, "For the state trying to extradite to spy on the defendant's client-lawyer consultations is in itself grounds to dismiss the case. This point is undoubtedly true. Any decent judge would throw out the case summarily for the outrageous spying on the defense lawyers." And even went on to talk about the CIA not only spying on him, but actually considering kidnapping him or poisoning him. So, yeah, they're not concerned with the rule of law here. And it's also abuse of process, because we're talking about deliberate misrepresentation of the facts, specifically about the threat that the publication made to operatives. It was not true that there was any evidence of harm to informants, and the U.S. government had confirmed this in other fora, e.g. in Chelsea Manning's trial. There had been no conspiracy to hack computers, and Chelsea Manning had been acquitted on that charge at court-martial. Lastly, it was untrue that WikiLeaks had initiated publication of unredacted names of informants, as other media organizations had been responsible for this first. While the U.S. allegation of harm to informants is widely reported, the defense's total refutation on the facts and claim that the fabrication of facts amounts to abuse of process is not much reported at all. So you're getting here what people are not getting in the mainstream media. We've heard over and over and over again for years about the harm and the threat that Assange's revelations made to operatives in the field. The fact that that is not true, and they have known that it isn't true, is hardly ever, if ever, reported. Go talk to the average man on the street who watches the news media. He'll tell you that, yeah, Assange put those people in harm, and that's the problem. It's not true. It was never true. We covered that in the podcast. So, he goes on to talk about the rest of day one. He gives you a link to the defense statement and gives a pull quote, really showing what we've all already known. This is a political prosecution. It's about political punishment, not the law. And that's pretty much the first day. So this has been going on for quite a while. So I'll talk about day two in the next video. We'll see you then. Until next time, stay strong and be free.